so I can see if I got a quorum to start committee of the whole. Are we got a counter? All right, it looks like we're doing okay. All right. Mr. Majority Floor Leader? Mr. Majority Whip?
Mr. Speaker,
Please.
I move that the House resolve itself into committee of the whole.
You have heard the motion. All those in favor say aye. Aye. All those opposed, no. Motion carries. Representative, and I'm not sure he's here. So it's Representative Western. Hey.
The committee of the whole will come to order. First bill for our consideration is House Bill 22. The reading clerk will read the bill.
House Bill 22, sponsored by Agriculture, State Land Lease Deficiencies, Cure Process, an act relating to state lands. Mr. Speaker, your committee number 5, Agriculture, State and Public Lands and Water Resources, to whom was referred House Bill 22, State Land Leases Deficiencies, Cure Process, respectfully report same back to the House with the recommendation that it do pass with the following amendments. Ayes. Representatives Alleman, Allred, Banks, Conrad, Crago, Davis, Eklund, Slagle, Winter. Representative Eklund, Chairman.
You've heard the reading. What is your pleasure, Chairman Eklund?
Mr. Majority Whip, I move that when the committee of the whole rises to report, it do so with a recommendation that House Bill 22 do pass. There is an amendment on the bill, and I will go ahead and move that amendment and work it into the bill. It is Standing Committee Amendment number 1 to House Bill 22. I move Standing Committee Amendment number 1 to House Bill 22. And I will explain the bill. So as the floor has seen by previous committee bills that we've done, we've worked a lot of state land bills. And I guess there have been some things that have precipitated that need to do some fixes. And most of them have been fairly small, but we believe it'll help the process in the state lands office. A lot of what's caused our problems was the COVID year, and there were communication problems. I would say that isn't it, all of it. The legislature has, over the 12 years I've been around, has cut every agency, some to bare bones, and I think it's been difficult for that office to administrate their programs. They've lost a lot of expertise with personnel, as well as they're usually shorthanded. And so the legislature has it isn't just the state lands office that has the problem. And then the other part, and this bill will hopefully address that, is sometimes our statutes don't allow the state land office to help producers that have grazing permits or whatever to come into compliance. So this bill, well, we were doing our interim committee work. This process called the CURE process is done on a federal basis. The act they used came out of the Administrative Procedures Act, and it doesn't pertain to grazing leases. It's more contracts and those sorts of things, but it's been applied on federal grazing leases and worked fairly well. And it amounts to a period of grace in which grazers can come into compliance. If they're a little out of compliance or something's a little out of whack, there's kind of a timeout and a period of grace. And it's been well received by everybody who has discussed it, and I'll try to explain it. One of the differences in what we're doing here and what was done previously is the state lands will initiate the process when a producer is out of compliance or a lease is about to expire. They'll contact the producer, and that's in the new language on page 2. One of the amendments brought in certified mail, and that would be at the end of line 19 via certified mail. So that's inserted into this section. Probably the most substantial part of the amendment is page 4, line 5. And it has to do with the timeline. Within 10 days of the receipt of the lease renewal application, the Office of State Lands and Investments shall notify the current leasee via certified mail if the renewal application is incomplete, deficient, and otherwise causes the Office of State Lands and Investments concern regarding possible lease renewal. The current leasee shall have not less than 20 days from the receipt of the notice to file a corrected renewal application. So this is part of the grace period in which they're able to correct compliance problems that they may have. I'm in favor of this bill because it just works on the principle that most of America works on, and that is to give grace and consideration to people that, especially in this area here, where our state statute really didn't have that. It was fairly clear that the leases would be terminated upon certain actions. This allows time for people to come back into compliance. And with that, I'll just stand for questions.
Any further discussion on Standing Committee Amendment number 1? Representative Washut.
Thank you, Mr. Chairman. I'm not sure this question is specific to the amendment. Maybe I'll wait till we get back on the bill.
We are on the amendment. It has been moved and we are on it. Any discussion on the amendment? Question being called. All those in favor of Standing Committee Amendment number 1 to House Bill 22, please say aye. Aye. All those opposed say no. That amendment is adopted. We are back on the bill. Representative Washut.
Thank you, Mr. Chairman. To the good bringer of the bill, I openly admit I'm a city boy. This is out of my area of expertise, but it seems like when these leaseholders fall into non-compliance, that it creates some administrative work. And I was wondering if there's any consideration of having a leaseholder who falls into non-compliance pay a fee or something for that added work that's created by the leaseholder failing to stay attentive to their responsibilities.
Chairman Eklund.
I think Mr. Majority Whip, to answer that, we haven't talked about penalties for being out of compliance. The real cost to the department is when these lands go into vacancy. And we have many parcels around the state that are in vacancy now. But there's been no talk. Usually, so the way the statute is now, if you go out of compliance, oftentimes, and you're about to go into vacancy or it needs to be renewed, the lease is terminated and people are just unable to renew the lease application. An example that we had during committee testimony was there was a person who sent off the renewal application, forgot to insert the check, and that cost them the lease on the property that they were working on. With this bill, it could have been corrected almost immediately, and they'd have been. But I don't think there are any penalties for. There are some consequences to being out of compliance, and our hope is that we can fix the compliance problems before we have to penalize people.
Representative Grego.
Thank you, Mr. Chairman. Just to follow up on that a little bit, this is really about just the applications. This isn't really about being out of compliance with your lease. And so it really shouldn't create any more additional work for the office, because what the bill is saying is, I submit an application for renewal, I forgot one little line, or I forgot to fill out one page, or I forgot to include the check. They have to review the application anyways. And so what this bill is saying is, okay, you rancher, you forgot the check, or you forgot to fill out this line, and it gives them a cure process, a cure time to remediate that problem. That's all it's really doing. And so then when the subsequent reapplication or corrected application comes back in, they'll just look at that and say, oh, yep, they fixed the problem we asked them to fix. And so that's really what this bill is about.
Any further discussion? Sensing the urge to vote. All those in favor of Chairman Eklund's motion when the committee of the whole rise to support it, do so with the recommendation that House Bill 22 do pass. All those in favor say aye. Aye. All those opposed say no. House Bill 22 has passed committee of the whole. The next bill for our consideration is House Bill 83. The reading clerk will please read the bill.
House Bill 83, sponsored by Representative Larson Lloyd. Tribal agreements to hunt and fish, an act relating to game and fish. Mr. Speaker, your committee number 2, appropriations, to whom was referred House Bill 83, tribal agreements to hunt and fish, respectfully report same back to the House with the recommendation that it do pass. Ayes. Representatives Henderson, Larson, Nicholas, Sherwood, Stith, Walters, Zwanitzer. Representative Nicholas, Chairman.
You've heard a reading of the bill. What is your pleasure, Chairman Nicholas?
Mr. Chairman, I move in the committee whole rise and report. It does so with the recommendation that House Bill 83 do pass. And I turn the explanation of the bill over to the good representative from Fremont County.
Representative Larson.
Thank you, Mr. Chairman. Folks, I hope this is kind of an interesting bill, and it's one that I think you'll want to be considering heavily in. And it revolves around an incident in 2014 when an enrolled member of a tribe in the state north of here and 2 other tribal members crossed over into Wyoming and killed 3 elk. Our Game and Fish charged this individual with a misdemeanor for unlicensed hunting and out-of-season hunting. He was convicted in state court. The person who shot the elk claimed he was granted rights as a member of his tribe to hunt on unoccupied lands by the tribe in the tribe's 1868 Fort Laramie Treaty. The state claimed, based on a 1896 Supreme Court ruling on a case that originated down in southwestern Wyoming, where a tribal member from an Idaho tribe come into Wyoming and shot an elk in a similar fashion, that the Supreme Court ruled that in that case, the state had a right to press charges because Wyoming's statehood had abrogated the tribe's off-reservation hunting rights. This decision has been the law of the land since that time in 1896. This current case, however, was appealed to the Supreme Court in May of 2019, and it overturned the lower court decision and said, and the Supreme Court found no evidence that statehood abrogated the treaty rights of Indian tribes to hunt off-reservation lands. This decision, folks, has set aside state law based on that 1896 decision, which again has to this point been the law of the land. Similar to the 1868 Second Treaty of Fort Laramie with this tribe that we're referring, the 1868 Fort Bridger Treaty between the Eastern Shoshone tribe here in Wyoming, and which I'll bring their name because they're in the bill, and an Idaho band of Indians has the same language, allowing for hunting on unoccupied lands outside the reservation. The current decision of the Supreme Court leaves ambiguity in the state's right to manage wildlife and conservation and treaty rights to hunt off reservation. In May of this year, the Eastern Shoshone tribe approached the governor's office and suggested the tribe and the state work together to define and establish a process to respect the conservation efforts of both the tribe and the state while addressing the hunting rights of the tribe with the tribes and the state, with the right the state has to manage wildlife. The result of that collaboration between the state and the tribe, along with Tribal Fish and Game and Wyoming Game and Fish, is this bill where we grant the governor the authority to negotiate off-reservation hunting agreements with recognized Indian tribes to codify their hunting and fishing and trapping and gathering rights. Now, in granting this authority, we establish guidelines based on current and best wildlife management practices, and is as much more responsible way to make sure that we all have good regulatory structure in place so that we don't need to wait for someone else to test the case or wait for the courts, the higher courts, to determine how the state should process this work. In the bill, and what the bill does is authorizes the governor on behalf of the state to enter into agreements with federally recognized tribes concerning hunting, fishing, trapping, or gathering claims based on treaty or other federally recognized rights on lands located in Wyoming. The bill provides sideboards to this authority we give to the governor, including it must be consistent with our current state statutes. The tribe must have and effectively enforce a game code that provides for the issuance of a license and adopts substantive requirements of game and fish statutes that we have in our the fundamental statutes we have in 23.3.101 through 23.3.407. Tribal members must have valid tribal or state hunting licenses. It specifies of enforcement over tribal members by state and or tribal authorities will be negotiated. The tribe, on its part, will align hunting, fishing, and trapping seasons with the state, with limited exceptions for ceremonial, religious, or traditional purposes, abide by area closures set by Wyoming Game and Fish Commission for Conservation, collect and share harvest data, set appropriate quotas, daily, and position limits broadly consistent with the state. Tribal hunting, fishing, trapping, and gathering will all be subject to the state's right to regulate when necessary for conservation, and nothing in the bill contemplates affecting private land. So with that explanation, Mr. Chairman, I would be happy to answer questions.
Members, any discussion? Representative Burkhart.
Thank you, Mr. Chairman. So for the bringer of the bill, a question, we talk about tribal lands and that, and I think when we talk in-state, I've always found the in-state tribes to be very easy to work with, very cordial, and they've helped me with some issues that I wasn't familiar with. My concern is we have other tribes literally all over the country. If the expectation is that we exercise these agreements with numerous tribes, literally as far as the Atlantic Ocean. So just some explanation of that. I could see this kind of getting really big when I don't think we want it to be.
Representative Chestik.
Thank you, Mr. Chairman. I do have some concerns about this bill. The good representative from Fremont County has told us that there was an agreement with the Eastern Shoshone. I don't know, and sort of along the lines of the previous speaker, I don't know if the Northern Arapaho are on board with this. I think there is, so I guess first my question is what other tribes have, or nations have been consulted with this, and what are their positions with regard to this? The reason I'm concerned about it is the sideboards that the good representative from Fremont mentioned appear to me to be very one-sided, very pro-Western, and very much opposed to tribal or the Indian nations' prior treaty rights. Now, I understand that the current state of the law is that the original treaties are now, according to the Supreme Court, in effect. So do these sideboards impose Western values on these lands over the wishes of the Indian nations? So I'm not sure how I'm going to vote on this, but I have concerns about it, and I don't want to trample the rights of the Indian nations and impose our Western values over them because we can.
Representative Larson.
Thank you, Mr. Chairman. So members of the House, there's your arguments. One side, we've got the state and how much do we want to expand or have the ability to expand. On the second question is, well, tribes have a right, and are we putting these restrictions in so tightly that we're pushing them out? And the concern that we've had since this case was overturned by the Supreme Court is it really did leave ambiguity in how the state and the tribes could function according to the state's rights and the tribal rights. And so having this put together in collaboration, again, between the Eastern Shoshone tribe, who with their fish and game, and the state with our game and fish, have put this model together. And as the committee heard the other day and heard from the representatives, the vice chairman of the Eastern Shoshone tribe is of their support. The question was asked about the other tribe that we have on the Wind River Reservation, the Northern Arapaho tribe. They have been consulted after this agreement was drafted, put in bill form. They've reached out to them, but their treaty does not have the same language, and so they were focusing on those treaties that had that language that allowed by treaty to hunt off reservations on unoccupied lands. To the chairman of the Minerals Committee, that's really, putting this in place is really important because he's exactly right. There are other tribes who can and may claim to have the right to, that this was some of their hunting territory prior to treaty. Now, depending on what their treaty languages say, but the governor would be able to negotiate with him, and having in place an existing agreement with the tribe helps lay the foundation and the precedent on what he's allowed to do or can do with the other tribes. It also really helps to set into place that the state has made a good faith effort in making these negotiations in a collaborative manner so that the Supreme Court doesn't step back and say, you just haven't done it, so we'll do it for you.
Representative Chadwick.
Thank you, Mr. Chairman. As I was listening to the good bringer of the bill in his narrative, he mentioned a couple of times unoccupied lands. I don't know what that means. Could you please define that for us?
Representative Ottman.
Thank you, Mr. Chairman. To the good representative that also is in my county, I want to thank everybody that works together on these issues. I know it's been a long and hard discussion. I just wanted to ask, when we talk about gathering and when we talk about ceremonial, have we given definitions for what that might look like? Is that something that can be designated and deemed by an individual, or will that be kind of documented so that we can understand when that might be? I also think that I've heard movement from some other tribes up in the northern state above us, that they are considering that they may be part of the one tribe, the Shoshone. So just if you have any information on that, thank you.
Representative Alman, could you repeat that question, please?
Yes, thank you. I had heard in one of the tribal meetings from some of the elders in a tribe to the north and west a little bit, that they are considering that they are part of the family of the Wind River Reservation. So just if there's any information on that. Is that good?
Representative Larson.
So thank you, members. These are really excellent questions, and I'll start with the last one first. The other tribe that the good representative from Fremont County pointed out to is actually one of the signatories of the Fort Bridger 1868 treaty, which allowed them, per that treaty, arguably to have rights to hunt in unoccupied lands in the state. And so they, in fact, they testified, their council testified at our committee meeting, they would prefer to have sole authority to determine how they hunt in Wyoming under the Supreme Court law. We, working with the Eastern Shoshone tribe, feel like that it needs to be structured between the parties who both have rights. Then on the gathering, if you'll look on page 5 of the bill, gathering means sustainable, non-commercial collection by hand of naturally occurring vegetation of non-mineral surface materials for personal, ceremonial, traditional, or religious use. Gathering shall not mean the harvest of fish or wildlife. In reality, those tribal members who are citizens in the state currently in Wyoming have the right to gather, as do you and I, where on state lands and on federal lands where appropriate. Of course, private lands would be restricted by the private landowner. Unoccupied lands, great question, and that's not fully been defined yet, and that's one of the things that was remanded back to the lower court. And so when the tribes claim that where they shot the elk was unoccupied, the state's position that because of statehood it was occupied, and that's been kind of, they're saying, is that where there's human occupancy or structures or buildings? That's not been clearly defined. There are yet some portions of this case that are being decided in the lower court, and really to add a little more wonkiness to the case is the individual who shot the elk was also later convicted of another crime that he's been convicted of, and sentencing has taken place. And so that individual's kind of been pulled out of this picture, but the case kind of moves forward along that. And so those are some of those issues that will have to be defined as it moves forward.
Speaker Summers.
Mr. Chairman, on and in favor of the bill, I think what we have to ask ourselves, would we rather have a framework of negotiation, or do we just want the courts to rule on these issues? And I think we want a framework for negotiations with our tribes. So on in support of the bill.
Chairman Nicholas.
Ladies and gentlemen, on in support of the bill, I can tell you initially I was fairly hesitant about this bill. I grew up in Fremont County. I attended school at the St. Stephen's Indian Mission. But I'm also a practicing lawyer, and so there's lots of different issues that come to my head as I mold through this process. I think one of the interesting, which I think is unique, that I found attractive about the way this is drafted, is even though the governor has the opportunity to negotiate, he can't negotiate anything that's inconsistent with our statutes or the Game and Fish rules and regulations. And so in terms of quotas or where they hunt and when they can hunt and things like that, those have to conform to what already exists. And so the only way that I believe that this can work is through a collaboration and agreement between the tribes and the state of Wyoming through our chief executive. And we're going to have to see if it works and see and test the waters, I believe, before we ultimately know the answer to this. But this bill as written also provides that if there is a violation of statute that comes out of the result of the negotiations, that has to be basically undone or reported, and the treaty has to, the agreement, not a treaty, has to be modified to be consistent with our statutes, which gives us, once again, the authority to modify our statutes if we so choose. But the question is, the case by itself, this is a criminal case that was in circuit court, went to a district court, was not reviewed by our Wyoming Supreme Court. And so the facts are interesting, and how this whole issue arose is just rather unique. But this concept is going to come back, and we're going to address it over and over again. In fact, we had testimony in appropriations when we look at this bill from a member of the Shoban tribe in Idaho, who was more of a strident position, saying the states simply cannot prevent us from hunting anywhere at any time. And fortunately, the folks from Fort Washakie are saying, we want to be reasonable about this. We want to work with you and come to a resolution that's consistent with Wyoming law, but also with our the rights that we have from the treaty. So ultimately, my conclusion was, I don't think we have anything to lose with this, but we have a lot to gain by being citizens and neighbors and friends as we move forward in this process. So on and in favor.
Representative Oakley?
Thank you, Mr. Speaker. On in support of the bill, I just want to be very clear that it was my community members, the Eastern Shoshone tribe that approached the state, that approached the governor, so that they can say, we want to discuss this. What are we going to do? We can come to an agreement. We want to be at the table and have a say in what this agreement looks like, and so we can all understand. So, and then the other official tribe that's in my county is also aware of this, and they're watching interestedly. So, so I think, this gives us the opportunity for both the tribes and the state to move forward in coming to an agreement that everybody can understand. So, on in support.
Representative Penn?
Thank you, Mr. Chairman. I stand on and for this bill. This is a process that came about by collaboration with the tribes. It does work to clear up ambiguity that has kind of been left with some of the court decisions and such over the years. And I think that this works to facilitate handling these situations that, as have been discussed, are likely to continue to come up in the future, and just helps, I think, move this process forward.
Representative Chestik?
Thank you, Mr. Chairman. I'm still concerned about the bill. Some of the discussion we've heard on the floor so far says that this gives the opportunity to negotiate with the tribes, and that's a good thing ordinarily. And I agree with negotiations. I agree with coming up with agreements. But I don't think the bill sets up a fair negotiation system, because the sideboards that we've talked about put some restrictions on the governor's ability to make a deal. There are certain things that are non-negotiable, and that's what the sideboards are. The governor may not negotiate away certain things. And that's not a fair negotiation when one side says, we'll negotiate with you, but we're not going to give you any of these things. Those are off the table. And that concerns me. I'm still undecided on how I'm going to vote on the bill. I do appreciate that some of the nations have engaged with us and are in support of this. Others apparently are not. So I just want us to think carefully about setting up a negotiation regime that ties the hands of one side and says, we're going to win on these issues all the time, and therefore it's not really a fair negotiation.
Representative Larson? Question being called. All those in favor of Chairman Nicholas's motion, when the committee of the whole rise to the report, to do so with the recommendation that House Bill 83 do pass. All those in favor say aye. All those opposed say no. House Bill 83 has passed committee of the whole. For our next bill, Representative Yin, privilege of the floor.
Privilege of the floor, Mr. Chairman.
Go ahead.
Mr. Chairman, in our, I believe, the north balcony, we have the mayor of the town of Jackson, as well as one of our town councilors, Jim Rooks, and Haley Morton Levinson is our mayor. Please give them a warm welcome to the House of Representatives.
Representative Pendergraft.
Thank you, Mr. Chairman. Privilege of the floor.
So moved. Proceed.
In the south balcony, if you would stand, Mr. Mayor, the mayor of Sheridan, Wyoming, Richard Bridger.
Respective mayors, thank you very much for coming down to the People's House. It's good to have you here. The next bill for our consideration is House Bill 169. The reading clerk. Oh, my apologies. Representative Ottman.
Thank you, Mr. Chairman. I just wanted to say today is the birthday of our House Majority Secretary. And so, Carol, happy birthday. So if everybody could just say happy birthday.
Happy birthday.
Yeah.
We wouldn't go very far without Carol Clark. Representative Oakley, do you have a privilege of the floor? Oh, all right. The next bill for our consideration is House Bill 169. The reading clerk will read the bill.
House Bill 169, sponsored by Representative Harshman. K-12 post-secondary education options, an act relating to education. Mr. Speaker, your committee number 3 revenue, to whom was referred House Bill 169, K through 12 post-secondary education options, respectfully report same back to the House with the recommendation of do pass with the following amendments. Ayes, Representatives Baer, Byron, Harshman, Locke, Northrup, Storer, Strzok, Swanitzer. Noes, Representative Oakley. Representative Harshman, Chairman.
You've heard the reading of the bill. Representative Oakley. Or what is your pleasure? Representative Oakley. Chairman Harshman, excuse me. Or Vice Chair Oakley, my apologies. What is your pleasure?
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report, it do so with the recommendation that House Bill 169 do pass. And I further move the adoption of Standing Committee Amendment Number 1, and I turn the explanation over to the bill sponsor.
Chairman Harshman.
Thank you, Mr. Chairman. Members, this is a short little bill. We might be able to set a world record, perhaps less than 2 minutes. Okay, thank you. All of our 48 school districts, it's in 21-2201, the Wyoming Post-Secondary Education Options Program. All of our 48 school districts offer post-secondary options to all of our high school kids in every high school in Wyoming, and really do a great job. Some districts do really unbelievable work, and you have many kids in our state that graduate high school with an AA degree when they graduate with their high school diploma. This bill simply
On page 2 of the bill, amends the last paragraph to that section of statute. You can see we add on, and I appreciate the amendment, really changes the language that I proposed in this bill. Appreciate the group genius of the Revenue Committee and working that out. So at this time, Mr. Chairman, I'd ask for a question and the vote on the standing committee amendment, and then I can just explain it quickly.
Any discussion on standing committee amendment number 1? Sensing the urge to vote. All those in favor of standing committee amendment number 1 to House Bill 169, please say aye. Aye. All those opposed say no. That amendment, or standing committee amendment number 1 is adopted. We are back in the bill. Chairman Harshman.
Thank you, Mr. Chairman. So members, if you flip over to page 2 of that bill, it'll simply say, it gives a little bit of a goal or a marker for our school districts. If you read 21-2201, there's a lot of shall words, and those are in existing language, but on line 7, it'll now read with the amendment, to make these options and programs pursuant to this section, then on line 7, reasonably accessible to eligible students, which shall include ensuring access to a minimum of 12 post-secondary credit hours to be completed in grades 9 through 12. That's the bill, Mr. Chairman. I'd stand for any questions or call for the question on the bill.
Any discussion? Representative Jennings.
Thank you, Mr. Chairman. So to the good bringer, I would just like to ask, how does this change it where it says to the greatest extent reasonably possible?
Chairman Harshman.
Mr. Chairman, so if you, on this, to the standing committee amendment that we just adopted, the stricken language is to the greatest extent reasonably possible is stricken. We just voted on that and adopted. So the language now reads, reasonably accessible to eligible students, which shall include ensuring access to a minimum of 12 post-secondary credit hours. And I appreciate that question, because that was, it was a good bit of work by our committee. We had about 4 or 5 different amendments moving the word shall around, and this is what we ended up best, that worked best. So thank you.
Representative Washut.
Thank you, Mr. Majority Whip. For the bringer of the bill, the language in terms of which institutions they're going to partner with is broader than just the university and the community colleges. Would you explain the rationale? What was the committee thinking with that?
Chairman Harshman.
Mr. Chairman and members, that's existing language. That's in statute long before many of us were here. And actually, if you go back into the earlier paragraphs of this section, A, B, C, D, E, F, and G, it actually talks about not only these entities spelled out, but any other entities that a local school board could be a tech school in another state. Now, I don't know any of that's happening, but it's pretty broad language. So, but that is existing language. We just put the goal on the end of this paragraph. Thank you.
Chairman Northrup.
Thank you, Mr. Chairman. This is a great program. I've seen other school districts have great success with it. There's a little town that's up by our country. That town commonly graduates 30 credits on their almost every senior that gets out of there. Like the good chairman said, when they come out of college or come out of high school, they do the high school graduation in the morning, and they go over to the college and get their diploma if they so wish. It's that seamless. It is just working really well. We're just making sure that we make it available to everybody, and that's why the language is the way it is. Vote aye.
Any further discussion? Question being called. All those in favor of Vice Chair Oakley's motion, then when the committee of the whole rise to the report it do so the recommendation that House Bill 169 do pass. All those in favor say aye. Aye. All those opposed say no. House Bill 169 has passed the committee of the whole. The next bill for our consideration is House Bill 144. The reading clerk will read the bill.
House Bill 144, sponsored by Representative Strzok. Senior Citizen District Programs and Services, an act relating to senior citizen service districts. Mr. Speaker, your committee number 3 revenue, to whom is referred House Bill 144, Senior Citizen District Programs and Services, respectfully report same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Baer, Byron, Harshman, Locke, Northrop, Oakley, Storer, Strock, Zwanitzer. Representative Harshman, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Harshman?
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report, to do so with a recommendation do pass on House Bill 144. Further move the standing committee amendment and a do pass on that. And we'll turn the explanation of the bill over to the good representative from Converse County, the prime sponsor, for the explanation of the amendment and the bill. Thank you, Mr. Chairman.
Representative Strock.
Thank you, Mr. Chairman. So this mill levy provides an important stable revenue stream to the programs and services that are provided the senior population of Wyoming and through the senior citizen centers. An important aspect of this statute as it was passed is that it's totally under local control. And so the purpose for this bill is to clarify what the special district boards are authorized to use the funds for. Current language in the statutes is contradictory and confusing. And so it is our belief that this revenue should be used solely for senior citizen programs and services as stated in the bill. But the current language in the bill restricts the board from distributing funds to the senior centers for the purpose of real estate, and we have left that restriction in. And as per the Converse County Treasurer, the residential property owners pay about 4.5% of the revenue collected by this mill levy, and businesses pay about 8%, and the balance comes from the mineral industry. And the current language in the statute prohibits use of the funds for capital construction, and capital construction covers a broad range of necessary activities. And this limits building maintenance, upgrades, and et cetera. So we have removed that restriction and defined how the funds can be used for capital construction. In discussions with our local boards, we came to realize that in our community, the public perception of senior citizen programs includes nonprofit, locally controlled subsidized housing for senior citizens. And for that reason, we have included that in these changes and have outlined how the board can use these funds for that housing. The changes in this bill will allow the boards across the state to responsibly utilize the revenue generated by the mill levy in their counties. Thank you.
Any further discussion on Standing Committee Amendment number 1? Any further discussion? Sensing the urge to vote. All those in favor of Standing Committee Amendment number 1 to House Bill 144, please say aye. All those opposed say no. Standing Committee Amendment number 1 is adopted. We are back on the bill. Representative Crago.
Thank you, Mr. Chairman. I just got some questions, I guess, that came from our constituents my constituents back home, actually some of the people that are involved with our senior citizen district. And one of the questions, and I'll just give a whole list and we can probably walk through them, but the first question is for the purposes of this statute, what constitutes income-based or income restricted? Where exactly can this money go? And, for example, in my district, we have several low-income housing projects. Which of those will qualify to receive, quote unquote, essentially what we're doing is we're giving grant money, looks like to me, out to these other entities that are not necessarily related to the senior citizen district. So which of those will qualify and where's the line drawn there? And that's my first question, then I'll come back with some more.
Well, as far as I understand.
Representative
Oh,
Strock.
sorry.
It's okay.
Thank you. That's what happens when you're new, isn't it? So thank you, Mr. Chairman. So what my understanding is just for the nonprofit, and it's what the money will be used for. So what we have at our situation was we have some HUD buildings that are right there by the senior center. And it obviously is for the elderly, and we needed to do some maintenance. They had an elevator that is broke down and there wasn't enough money for it, but our senior center has plenty of money and we are not able to use it for maintenance. And so this is what it's to be used for the nonprofit housing. Thank you.
Representative Larson.
Thank you. The good bringer of the bill had some really interesting stats, and I'd like to ask her if she'd repeat those. She talked about where where the revenue of this came from, and I was trying to write it down. It sounded like there's like 4% that came from residential property tax and 4 or 8% maybe from commercial, and then the rest came from industrial. So are we saying that like 82 or 83% of that's funded by our extractive industries?
So,
Representative Schrock?
Mr. Chairman, thank you. So what we have is that 8% was from businesses, and then the rest of it, and the 4.5% is from the property owners, from property tax, and the rest of it is from the mineral industry. Yeah. And sorry, we are very wealthy that way in Converse County. Would love to share the, hopefully they'll be drilling all over the state, and the rest of you can be wealthy with us.
Representative Craigo.
Thank you, Mr. Chairman. So my next question is during the committee meeting and during testimony, was there any questions or conversations about how this will affect the elections to keep the mill in place going forward? I can tell, and the reason I ask this is, for example, in our county, one of the selling points of the mill is every dollar goes to services. It either goes to food or providing programs at the senior center. And one of the ways we were able to get it passed overwhelmingly in our county is we're not buying real estate. We're not buying additional buildings. We're not putting that money into things that are going to require additional monies. Every single dollar goes right to the seniors in our county, whether it be through food services, et cetera. And so I guess my question was there any discussion regarding that?
Representative Stith?
Mr. Chairman, thank you. A question I have concerning the bill is just what's included in lower income housing facilities. Is that just HUD housing? Is it housing that's owned by anyone who's low income? How broad is this? And just the baseline here, because I haven't thought through the bill as much as I should, is it sounds like this senior citizen district will then get into the home maintenance business, essentially, and start, repairing roofs and porches and, rebuilding houses that are not owned by the district. So the most basic question is, does this contemplate that senior citizen district money will be used to improve property that's not owned by the district?
Chairman Zwanitzer.
Thank you, Mr. Chairman. Let me take a couple steps back and help out this bill by reminding you all this is a special district of a senior citizen district. It's defined in 1815-101. So your county sets up one of these for the benefit of the seniors in your county. And we've only had these since the mid-90s, right? And so when they put this statute in and thought about building, a senior center and a facility for the seniors in your community, they probably didn't really think about what would happen in 25 years when some of those facilities became dilapidated and might need repair. We've done a lot of maintenance on ours here in my community, and we actually approved some money in our 6-penny tax to build a new one. And that's separate from our senior service board. It was part of our 6-penny tax, but those are the ways we are trying to benefit our seniors. And so the ultimate answer is whatever your board of directors of your special district, your senior center special district, think is important for the seniors in that district, they can do, right? And in some cases, it might be programs. In some cases, it might be better nutrition. In some cases, it might be mental health. So what we're trying to do is now, after 25 years of having this statute in place, is take a step back and saying, good intentions, but like everything else, we need to kind of incorporate, some unforeseen things about maintenance, about maybe building a new building, things that benefit the seniors in your community. There are safeguards all throughout 1815-101 through 111 on what this board of directors can and can't do. When we're talking about maybe they want to assist with senior citizen housing, that doesn't necessarily have to be at the senior center anymore under this bill. That's really what it's saying. So if my county, right, our senior service center is actually right next door and actually kind of attached to a 8-story building that provides housing for seniors. What this would allow is you don't actually have to connect your senior center to housing. You could actually benefit seniors at a different facility as long as A, it's for senior citizens, B, it's a nonprofit and not making any money, and C, it's at the behest of the board of directors of that special district that you're paying into. And so, yes, they're varied. Everybody's county who has one is probably a little different, right? And that's the great thing is if you want a special district, you can tailor it to the needs of what the needs in your district are. And so I think it's just time, in this case, we're expanding it a little bit for things they didn't think about 25 years. When you get to the point where, you can't just keep putting Band-Aids on a building. Maybe once in a while it's time to build a new one, or maybe once in a while it's time to say it doesn't have to be attached to your senior citizen center to be able to get some senior citizen funds to help with their housing, right? Because we all know the elderly are on fixed incomes, and sometimes, they need affordable housing just as much as everybody else. And it's not workforce housing because they're not workforce, it's senior housing.
Representative Craigo.
Thank you, Mr. Chairman. Maybe a question for the former speaker, the good chairman. Could you direct me in the bill where it is restricted to nonprofits? And maybe I'm just missing it.
Chairman Zwanitzer.
Thank you, Mr. Chairman. You're not missing it in the bill. It is elsewhere in the statute. And I actually had to look this up in committee because I was concerned about the same stuff, about how these funds could be used. I think it's in 1815-111. And if you give me just a second, it does say these all have to be nonprofit entities for the established maintenance of programs or services for senior centers or housing. And so I will get that citation to the good country lawyer, but it is in the Special District Act for senior citizen service centers.
Any further discussion? Representative Slagle.
And I may be confused after listening to all this debate on statutes, but a question that was asked by the constituents in my county was, State Statute 1815-108B does say, but shall not be used for the purchase of real property or for capital construction expenditures. So I was wondering how you guys see this fitting in with this statute. Thank you.
Any further discussion? Any further discussion? Sensing the urge to vote. All those in favor, Representative Brown.
Mr. Chairman, thank you so much. I'm actually just up here to delay for just a few seconds because there is actually another question coming, but we're running very, very quickly. So, Mr. Chairman, I'm hoping that we can take just 2 seconds here and get the other question that was being asked back here.
What? Representative Steth.
Mr. Chairman, this is the good chairman here. My question would be to what if the local property is low-income housing owned by another governmental entity, say owned by the municipality? Is this going to authorize using the senior center district funds to, essentially do the maintenance or improvements on some other real estate that's owned by some other governmental entity? Is it that? Just how expansive is this construction fund, I guess, is my question.
Any further discussion? Representative Craigo.
Thank you, Mr. Chairman. And just to, I guess, to piggyback on the last speaker, and this goes back to some of my earlier comments, is not only could it be owned by, are we doing improvements on buildings owned by another government entity? Are we doing improvements on buildings not owned by another governmental entity? And that was my question regarding nonprofits. Are we, even if we're limiting to nonprofits, is that a good use of our money? And that's just a question for the body to decide as we go forward on this bill.
Any further discussion? Representative Strach?
Thank you, Mr. Chairman. I guess here is really what it comes down to. We're doing this for the elderly. We voted how many years ago? I think they know better than I do. I'm sorry. As in your county to take care of the elderly. You would take some mill money, levy money, and you would take care of these elderly. So are we only going to feed the elderly, or do we get to make sure they have some bathrooms they may need, even in the senior center? Do you realize that we weren't even able to use that money to make more bathrooms? You were only supposed to feed them. So are we going to take care of the elderly? Or are we going to take care of the elderly? It's the same people we're taking care of. That's the question here. I think we need to remember who we're taking care of and why we're taking care of them. Thank you.
Chairman Zwanitzer.
Thank you. 1815-111. Let me read you a couple. Establishment or maintenance of programs or services for senior centers is currently allowed. As part of that, the district can provide directly or contract for the provision of senior center programs or services. Participation has to be through the Department of Health, and you can require any provider, if an organization or agency, to be incorporated under the laws of the state as a nonprofit corporation prior to the receipt of any funds. And so we're already allowing this if it's a program or a service to come in. Why would housing, it's not specifically spelled out in the statute now, and that's why the expanse is probably needed, right? If we're feeding, clothing, helping them with their healthcare needs, why would we not provide housing at an offsite location as a potential for those districts who wanted it to be able to engage in it? And again, it just means it doesn't have to be attached to the senior center. And that's not right for every county. And so I think it's a really good expansion in this part of the statute for this bill, and I would encourage your aye vote.
Question being called. All those in favor of Chairman Harshman's motion on the Committee of the Whole rise to report, do so with a recommendation that House Bill 144 do pass. All those in favor, say aye. Aye. All those opposed, say no. No. House Bill 144 has passed Committee of the Whole. The next bill for our consideration, Speaker Summers.
Privilege of the floor.
So moved. Please proceed.
Thank you. Thank you. Ladies and gentlemen, up in our West Gallery is a young, he's not so young anymore, but he's the mayor of Superior, Dominic Wolf. And he worked for me as a hay hand when he was a young man. And I'd just like you to greet Dominic.
Thank you for your attendance. I'm sure the hay bales were not light on the Good Speakers Ranch. Representative Grego.
Thank you, Mr. Chairman. I also wanted to introduce the mayor from Buffalo. I think he's up in the South Gallery, Mr. Shane Schrader, and welcome him to the People's House.
Thank you very much, Mr. Mayor, for coming. If I know you were coming down, I would have asked you to bring some dash in for all of us. The next bill for our consideration is House Bill 64. The reading clerk will please read the bill.
House Bill 64, sponsored by Capital Finance, Legislative Stabilization Reserve Account Obligations, an act relating to public funds. Mr. Speaker, your Committee Number 3 Revenue, to whom is referred House Bill 64, Legislative Stabilization Reserve Account Obligations. Respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Bear, Byron, Harshman, Locke, Northrup, Oakley, Storer, Strzok, Zwanitzer. Representative Harshman, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Harshman?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report, to do so with a recommendation that House Bill 64 do pass. And we're going to turn it over to the good representative from Fremont County. This is a capital finance and investment bill. Now, a couple bills ago, I said 2 minutes. It actually took 4 minutes, 50 seconds, I was told. This bill guaranteed 2 minutes. Thank you, Mr. Chairman.
Representative Larson.
Thank you. Mr. Chairman, what we do in this bill is with our LSRA account, we have like $1.5 billion in there. And what we have done in previous legislative sessions is we've committed some of that money as a backstop. So like for YDOT, we've says they can if they needed to, they could have access to 200 million in a loan, for a loan, and then we put the repayment of the loan. We had for A&I that they could borrow up to 60 million for shortfalls in insurance, and we said to the state unemployment compensation plan, there's a federal and a state plan, if that runs short, that they could borrow up to 60 million. Whenever you do that, that makes the investment of that for those amounts, so there's 200, almost 300 million there, that has to be at a much lower interest rate. So we're reducing the YDOT amount to 100 million, and then the others we're just removing because they have sufficient funds in their existing corpuses to handle. They don't need the interfund loans. The state unemployment fund, they've got plenty in theirs, and EGI has plenty of theirs. So that's what this bill is doing, and that will allow for that commitment to be gone, and they can invest that amount of the LSRA into a higher return. With that, I'd answer questions.
Question having been called, all those in favor say aye. Aye. All those opposed say no. House Bill 64 has passed committee of the whole. Next bill for consideration is House Bill 66. The reading clerk will read the bill.
House Bill 66, sponsored by Representative Ward, prohibiting mask, vaccine, and testing discrimination, an act relating to public health and safety. Mr. Speaker, your committee number 10, Labor, Health, and Social Services, to whom is referred House Bill 66, prohibiting mask, vaccine, and testing discrimination, respectfully report same back to the House with the recommendation that do pass with the following amendments. Ayes, Representatives Hornock, O'Hearn, Penn, Trujillo, Ward. Noes, Representatives Chadwick, Clauston, Yin, Zwanitzer. Representative Zwanitzer, Chairman.
You have heard the reading of the bill. Chairman Zwanitzer, what is your pleasure?
Thank you, Mr. Chairman. I move in the committee of the whole rise to report to do so with the recommendation that House Bill 66 do pass. I would further move the standing committee amendment and turn over management of the bill and the amendment to the good representative from Natrona County.
I think I have to be recognized by the speaker. I'm over here.
Representative Ward, thank you.
Thank you, Mr. Speaker. Thank you, Chairman. I'm going to talk about the bill first and the amendment second. So first, I'll explain the philosophical justification for this bill, and then I'll go through some of the specifics of the bill. So HB 66 eliminates discrimination for not wearing a mask, not receiving a so-called vaccine, or not getting tested. The bill protects individual liberty by requiring that all businesses, public and private, not discriminate against those who refuse to wear a mask, receive a vaccine or a so-called vaccine, or get tested. The bill proposes that you cannot be required to wear a mask, get a vaccine, or get tested to work, get an education, go shopping, or be treated at a medical facility. In short, to participate in society. Last year, the Wyoming legislature held a special session to protect our medical freedom with respect to masks and vaccines, yet failed to do it. This was a top priority for my constituency when I walked door to door this election cycle. I promised to protect the individual liberty of my constituents, and I will do my utmost to deliver on that promise. Late this summer, one of my daughters needed a sports physical here in Casper, where I live, in my district. We needed it quickly, so we stopped at one of the local health centers, and we were turned away at the door because we refused to wear a mask. I couldn't believe this was still a thing in 2022 in Wyoming, especially in Wyoming. The healthcare system has done more to destroy the trust of the American people than any other sector. I am prioritizing the rights of the individual, of we the people, Tyranny by big business or big pharma is one and the same as tyranny by big government. We, the people, are taking back our liberties. Government exists to protect, first and foremost, individual liberty. Private businesses do not own their customers or their employees. They don't have free rein to abuse us, and we're not their slaves. Requiring masks, vaccines, and testing to work, get an education, or be seen by a doctor is a form of discrimination that should be illegal. Businesses, public or private, have no authority to mandate medical interventions, especially those that potentially harm people and/or prevent people from breathing. Our government was formed to protect the rights of we the people, not we the businesses. Part of individual liberty is the freedom to do business without government interference, where the government has no authority. The reality is that most businesses, especially small businesses, and I've received several emails to this effect, felt pressure to mandate masks and so-called vaccines, and many did so very grudgingly. They didn't want this at all. I intend to fight for the business owners who want big government out of their way. I've been told by an opponent of my bill that this will cause Medicaid dollars to leave our state. We must make a choice between their dollars and our freedom. But will we sacrifice our freedom for their money? I hope not. I'm going to go through the bill a little bit. First page is self-explanatory. Page 2 is definitions, also self-explanatory. On page 3, line 8, and also line 21, it mentions public in nature. As I mentioned previously in my introductory remarks, public in nature means all businesses, public and private. On page 4, there's a misdemeanor. The penalty is a misdemeanor, and it's listed at $5,000 and 1 year in prison. In committee, we repealed the penalty. Also in committee, we repealed the fact that this originally applied to all vaccines, including the standard childhood vaccines. So the amendment, as it stands, has no penalty, and it takes out the fact that this bill would have applied to the childhood standard vaccines. With that said, I move the amendment and the bill. I move standing committee amendment number 1 to House Bill 66. Thank you.
Question having been called, all those in favor say aye.
Aye.
All those opposed say no. Standing. We are back on the bill. Representative Stith.
Mr. Chairman, so my question about this bill is that rather than protecting business owners, it seems like what it does is it tells business owners what they can and cannot do with their own business. That is, if you have a small bookstore, and for example, if you are a cancer survivor and you run a bookstore and you believe you are immunocompromised and you want during flu season people to wear masks in your bookstore, it seems like this bill would outlaw that. And so my question is this: how does it promote individual freedom? How does it promote individual liberty of a business owner to run their business as they see fit? That is, the question of whether you require someone to wear a mask in your business or be vaccinated or get tested or whatever, it seems like that decision is one that's not based upon a suspect class. That is, it's not race, religion, or gender, for example. It's not a suspect class, and so within that, why can't businesses make their own decisions about what services and to whom they want to provide those services? So again, so long as they're not discriminating based upon a suspect class. That's my question. This bill doesn't seem to advance freedom. It rather seems to be government reaching in and tell businesses how to behave.
Speaker Summers.
Mr. Chairman, thank you. And I have a question for the good bringer of the bill. And that is, you know, as I read the bill, it says person, and usually in Wyoming statute, person means corporation, company, person. It's very expansive. And so my question is on the mask piece, does this mean that a surgeon couldn't require a nurse to wear a mask in surgery? So that's the question I would have.
Representative Ward?
The intention of the bill, in answer to the good speaker's question, the intention of the bill is that it applies to COVID-19 mitigation measures. So it is not the intention of the bill to apply to operating rooms.
Representative Larson?
Thank you, Mr. Chairman. The bringer of the bill pointed out, and I just need clarification on this, that public in nature means public and private, but I don't see anywhere where that's defined. So is there someplace in statute that I'm missing that is indeed what that means? If not, then I don't know. Public in nature does not mean private to me. So, and then the second question I would have is one of the long-held values that we've had as in a conservative state of Wyoming is to protect the right of the business owner, and one of those rights is to have the condition of employment. And so if I were an individual, you know, and in my hiring practices, I said you had to wear a mask, this bill would say I can't do that. And I think that is inherently goes contrary to what this state has allowed, because if the person doesn't want to wear the mask, they don't have to. They just can't work for me. And I should have the right, it's my business, I should have the right to put those conditions in place. And it may be to my detriment, because all of my people may say, well, we're not going to wear masks, and so forget it. And because of the decision I make, I go out of business. But that's my right to do, and it shouldn't be big government stepping in and saying that I can't do that. Now, where am I seeing that wrong? If you can help me through that, because when we held the special session, that was one of the biggest concerns that the business associations and we as legislator had is now telling the private sector that they no longer have control of conditions of employment.
Representative Locke?
Thank you, Mr. Chairman. And that's actually a very good point, and I'll be perfectly honest with you. I'm a co-sponsor on this bill, and my very first question to Jeanette was, I can understand vaccines, and I can understand some of the other things. What about masks? Well, as it turns out, if you really look at this closely, masks, very much like vaccines, very much like being tested, are also a medical treatment. I only say that from this perspective. If you think about a mask, and there are many facts out there that you can find these research studies any place that basically show that wearing the mask long-term, all day long, can, and in many cases does, have very ill effects. So I bring that up as one point. But a second point that was made was this whole issue of, we're asking businesses to do this. And we think about it from where being from the location I come from, if I don't like working for this business, it's okay. There's another business down the street. That's not a problem. Well, let's think about where we live. We live in Wyoming, okay? So that being said, there are many of these towns around our beautiful state, our amazing state. And guess what? Almost every business in that town is virtually a critical service to that town because it's the only business. That affects the patrons, that affects the people who need to work. And we stop and think about that, and I understand, we say to ourselves, yeah, but the business will drive it. Well, that's partially true, right? In most cases, you make these decisions Nobody wants to work for you. I get it. But basically, ultimately, fear is a very effective hammer to get people to do things that in the end they know are not good for them. Okay? And then the second thing is, the minute government gets involved in trying to push money or force these things in place, then the businesses are going to double down. So my point is, there is definitely a crossover here. Do we protect the business or do we protect the individual? At the end of the day, every person, when it comes to protecting their health, has this responsibility for themselves. So I am on and for this bill.
Representative Stivar.
Thank you, Mr. Chairman. Again, Article 2, Section 38, right of healthcare access. In C, the legislature may determine reasonable and necessary restrictions on the rights granted under the section to protect the health and general welfare of the people to accomplish the other purposes set forth in the Wyoming Constitution. I believe we have a right to say no more masks. And that's what this bill's doing, on and for the bill.
Representative Hornock.
Thank you, Mr. Chairman. On and for the bill, I was in this committee listening to the discussion on it, and something that I want to remind the body is that it's still possible to post any sign you want to in your business that recommends that customers do a certain thing. That's still possible, but it will not be allowed to force somebody to do something. And then I want to read a couple sections of the Constitution as well. Article 10, Section 1. The legislature shall provide for the organization of corporations by general law. All laws related to the corporations may be altered, amended, or repealed by the legislature at any time when necessary for the public good and general welfare, and all corporations doing business in the state may, as to such business, be regulated, limited, or restrained by law not in conflict with the Constitution of the United States. And then you all know, because of this discussion going on for a couple of years, you all know Article 1, Section 38, where each competent adult shall have the right to make his own healthcare decisions. So I just want to keep those things in mind, that this is not limiting businesses. They can still recommend that customers do something. But I think we're overstepping our boundary constitutionally when we ask them and we force this kind of thing across the board. Thank you.
Representative Oakley.
Thank you, Mr. Chair. On and against. Of course, we've heard a lot of testimony on this bill. We've talked about a special session, and people got mad and are mad and frustrated, and I hear that, and I completely understand it. I think we all do. But by definition, freedom only works if it works both ways, if it works every way. Businesses have liberty, individuals have liberty. And we've got to grapple with that and find the right way, and we can do that. We can find compromises that work for everybody. But shackling some and imposing one set of values is not the way that we get there. Further, it's been at least alluded to, but I think probably a couple different ways it's unconstitutional. I know one of them, as it applies to our healthcare providers, it could be a violation of the Supremacy Clause, because they have been, and this has happened, in some places they're mandated to do something, and then in other ways they're prohibited. I mean, how can government do that to our healthcare providers? And that's what we're grappling with, and that's where we could put them. And then when they do that, if they don't follow the mandate, then they can lose funding. And this isn't what we want to do to our local businesses, and it's not what we want to do to our healthcare providers. Again, we can grapple with this, but the idea of, like I say, shackling some in the name of freedom just it doesn't work. On and against.
Representative Penn.
Thank you, Chairman. Body, I would just like you to realize for a moment that there are a lot of prayers for this body right now, for each and every one of you across the state, because this is a big issue for people, for our constituents. And so know that people are praying for us right now to have this debate and this argument, that our hearts can be open and that we can set aside our biases and our difficulties to come together to make the best decision for our constituents. So in my opinion, what we're dealing with here is whether or not it's appropriate for the state to be involved in this situation. And I would say that in this situation, we have a duty to step in when the rights and the individual liberties of people are being infringed upon. For my constituents, one of the greatest concerns when we had a special session on this topic, and afterwards, what I heard over and over again is that they just stood up for the businesses. They protected the businesses, and what about me? What about my individual liberties? When we're in this circumstance, when we're discussing the infringement on individual liberties, and we all know what we're talking about. We can sit here and we can debate on whether or not we think that a vaccine is effective or whether or not we think a mask is effective, and we can do that for days. But that's not actually the debate that we're having before us here. The fact is that hindsight, looking back on this situation, hindsight tells us that there were some mistakes made, and we didn't know what we were getting ourselves into, and so people wanted to do what was right and protect and look out for one another. But it comes down to the fact that we don't always know what's coming. And that's why it's important to protect liberty first, liberty of the individuals, of the people. If we are saying that it's okay to infringe upon liberties because we're protecting businesses, or it's okay to infringe on liberties because we need the funds that are going to come in if we don't, we need to reevaluate where our base is coming from. In our Constitution, Article 1, Section 7 says that no absolute arbitrary power over the lives, liberty, and property of free men. This exists nowhere in a republic, not even in the largest majority. So this deals with health. Coming from a healthcare provider, I support this bill. Is it perfect? We can't have a perfect bill in an imperfect world, but this is a start for Wyoming to be one of the first to stand up and say that we care about our citizens first. And there may be some struggles because of that, but we need to do the right thing by the liberty of our people. Thank you.
Chairman Washut.
Thank you, Mr. Chairman. I have two questions. Number one, what exactly are we accomplishing by passing a bill with no penalty provision? And number two, you mentioned someone had told you that some businesses might lose revenue from Medicare, Medicaid. I'm curious about how much that is. We have to make balances and judgments all the time about, two rights that kind of collide with each other. And that's what this issue is two rights kind of colliding with each other. So it sounds like we're being asked to gamble with the financial well-being of businesses that might lose Medicare or Medicaid funding. And, it's easy to gamble with somebody else's money, but I'm just wondering how much are we talking about? What kind of money are we talking about when we make this judgment about this versus their being able to get reimbursements on those federal programs? What's the amount we're talking about?
Representative Pendergraft.
Thank you, Mr. Chairman. I want to take a little step back
You need to understand that I have a background in nursing homes and have taught the use of personal protective equipment here and called PPE. As a soldier, I was vaccinated against near everything known to man. Those vaccinations were meant for my protection. They don't affect the people around me. PPE, likewise, is meant for my protection. It doesn't protect anyone out there. Now, if I sneeze and I have a mask on, it may make you feel better that you didn't get splattered. But if you understand the nature of the bugs involved in this, that mask that we like to promote and wear is totally ineffective. If it makes me feel better to wear it, I have a right to wear that if it makes me feel safe. If I want to get vaccinated, I have a right to get vaccinated. To have somebody come and tell me that I have to pump some experimental fluid into my body, I have a problem with. And to have somebody perpetuate the lie, if you will, the fantasy that putting a piece of paper over your face is going to stop that. There was an expression that was started out by a broadcast company that is public, and it said originally, they pointed out that this is like trying to stop a mosquito from going through a chain link fence. Well, they quickly changed their position, but quite frankly, that's what it is. I am on and for the bill.
Chairman Allred.
Thank you. Thank you for the title, too. Thank you. I appreciate the discussion here. I've had a lot of thoughts about this. I would like to remind the body that I think that businesses were victimized just as much as you and I were. Businesses are people. Businesses have faces. I have family in this state who are in business. And I'm having a real hard time with this bill putting my rights above those of someone else. Thank you.
Chairman Nicholas.
Thank you. I'd like the answer to a question to the second to the last speaker. The impact of this bill would be a loss of federal dollars in the amount of $847 million a biennium. So it's the equivalent to 1/8 of our budget. And so those dollars will simply go away. And so if the will of this body to take away $840 million in healthcare benefits that is provided to all of our seniors, to all of our single mothers, to our expectant low-income folks, so be it, for your personal glory. So what do the towns of Lovell, Lyman, Pinedale, Star Valley, Saratoga, and Fort Wasatch all have in common? They have roughly around 2,000 residents. That's how many people in Wyoming have died in the last 2.5 years from COVID. And frankly, most of the data suggests that that number is low. And I have several family members who died of COVID. I have a brother who's a doctor, a physician, who was in the hospital in a semi-coma for 3 months because of COVID. The problem with COVID is that it is contagious. It is highly contagious. And to suggest that it is not is simply, I think, a misnomer. And it's theory and belief over reality. And so, ladies and gentlemen, this is about protecting our Wyoming, your neighbor. It's about protecting your family. It's about protecting all of us. So you want individual freedoms. We have so many restrictions on our individual freedoms, and why just pick on this one? Because, frankly, because it's the subject of the day. The federal government requires us, limits our speed limit. Why in the world do I have to drive 75 miles an hour? Because the law provides for it. That's an invasion on my personal property rights. Personally, I think. Sometimes I don't always adhere to it. We have curfews. We have noise restrictions in our cities. We have speed limits. We have stoplights. You can talk about our restrictions on our personal freedoms ad nauseam. And there have been bills here brought restricting or expanding those freedoms every day. And so this is nothing special other than a firm belief that somehow you're not putting anyone else at risk if you don't wear a mask, if you have COVID. And I would just respectfully say that most medical data says that is incorrect.
Representative Bear.
Thank you, Mr. Chairman. I appreciate the comments from the good chair of appropriations, but I'd like to point out, though it may put 1/8 of our budget at risk, I can't even imagine the millions of dollars or hundreds of millions of dollars the state just south of us puts at risk when they legalize a certain drug that the federal government has not legalized, or when the state on our western border, not our western border, but on the ocean front, that has sanctuary cities. How many federal dollars do they put at risk? But their principles, which I disagree with, led them to go ahead and do it. And what have the consequences been? Let's think about that. Also, to the question brought by the good representative from District 55 about the Supremacy Clause. I can find nowhere in the United States Constitution where the United States government has authority over health and welfare. Health and welfare is specifically denoted for the states and the people. Thank you. On and for the bill.
Representative Alleman.
I'm on and for the bill, and more than that, I am for the great people of the state of Wyoming, and I will fight to keep their sovereignty, their liberty, and bring them justice. We talk about how I am a very big private property rights, and that a business ought to be able to do whatever they're big enough. But when we look at our businesses, the government is forcing them into so many things. In my little business, I have to collect sales tax and send it to the government. It's mandated by the government. I'm paid nothing to do that. We have to wear a hard hat and steel-toed shoes. We have to have PPEs and glasses. And this is all being forced on us by a mandate from the federal government. Finally, the people of Wyoming are saying businesses, we're putting a mandate on you so that we free up our state. Thank you.
Representative Parenza.
Thank you, Mr. Chairman. I have a question. So one of the first speakers asked about masks in hospital settings or surgery, and I'm wondering, and the response to that had to do with the intent of the bill, not, if it's not about COVID-19 pandemic. So I guess what I'm wondering, does this mean that ICUs can't then impose a mask requirement, or like portions of a hospital where they're worried about airborne disease? Can a medical facility do it at that point and require, or does this mean that we can't, that they would have to just recommend masks in those settings? Thank you, Mr. Chairman.
Representative Stith.
Mr. Chairman, I guess I'd like to hear from the advocates of the bill, from a theoretical point of view, why they think this does not infringe on the liberties of individuals. I have an individual right to smoke cigarettes. I can do that. That's not against the law. But if I walk into a restaurant, do I have that same right? Does the restaurant owner have to accommodate my individual right to smoke? Or if I walk into a dry cleaners, or if I go to a gas station and I'm filling my tank full of gas, do I still have the individual right to smoke while I'm filling my gas tank? It seems like the theory of this legislation is against individual liberty. You're telling individual business owners, you can't do something. You cannot make this a requirement of entering on the premises of your business. Why would we, who support individual liberty, why would we ever support this? It doesn't make any sense. Thank you.
Representative Haroldson.
Thank you, Mr. Chairman. So I am going to take a whack at that last conversation point, and I think to kind of lay a foundation for this, my prior life before I was a pastor, I worked at a coal-fired power plant there in the county where I reside, and in that coal-fired power plant, we are regulated by this government that we now sit in through entities. I mean, those green books that are sitting behind you have all sorts of rules that regulate, and this is why. Directly west of our said coal-fired power plant in that coal yard was someone's ranch. And it's amazing when the wind would whip up, as Wyoming wind does, how they would get completely inundated with coal dust to the point of drifts feet deep. And Wyoming's environmental quality group came in and said, hey, you can't do that. We're going to protect this landowner from you because you're actually taking away their rights to having quality of property, their property values. They had to go in there, they had to come in with heavy equipment, pull out fences, they had to remove all of this coal dust. That was a government regulation on a business to protect the right of a person. And so we're at a point where we have to understand, I mean, we were in committee the other day and we heard a House bill talking about the possibility of opening up a retirement program for private individuals, private businesses, so that we could take care of a bell curve issue in our state with a generation that doesn't have retirement. And one of the things we heard was it only works if it's mandatory for the business owner. Well, wait a second. If that's the case, so if we get this back and they do what they actually we do what they told us we have to do or should do, are we going to make that mandatory? So the point is, this government makes all sorts of things mandatory on businesses all the time. We have to be compliant for I can't say that. We have to be compliant for all of these different entities of our state. If you choose not to comply to that, you will be fined. Your license will be removed. I mean, you guys, at this point, if we truly live on this standard and basis, it's a free-for-all. And there are things that are put in place to protect employees, to protect those people. Well, you know what? For these employees that had to wear a mask for 2 years of their life, that are now having lung issues, that are having issues, they were required by an employer to wear something that breached their fundamental constitutional right, and now they're having to deal with it. And I think the real question here is are we here to say, hey, you know what? We are not going to allow you as a business to take someone's health in jeopardy. One of my best friends growing up had complications from the vaccine and died. And it was a situation where this is off of requirements by an employer, you guys. Requirements of you want to keep your job, you got to get vaccinated. I don't want to do that. Well, you have to do that. Well, it did it. 3 weeks later, he's dead. Well, they can't. Well, we don't know for sure it was that. Well, he was a really healthy young man that never had any heart issues, but he died. So now we have to start asking questions. Was that business's right to do that? To take away his health? To take away his livelihood? A 36-year-old young man that passed away? You guys, these are the questions we're asking right now. These are the conversations we have to have. And my voice is too loud. Probably don't even need this if we wanted to talk that way. So, you guys, really boiling it back down, the green books behind you, that's what they do. They put regulations on businesses to make sure that what we're doing is effective, intelligent, and safe. And we could go into this long conversation. Do masks work? Do masks not work? In the last place I worked, I had to be respirator fit tested, and I had to go through all sorts of respirator fit tests for all sorts of different things. I now have a beard because I wasn't allowed to have a beard before. You have to understand, COVID will not be stopped by any of the masks that we're wearing. If we truly wanted to stop COVID, we'd look like we're walking on the moon. So you guys, we really have to ask the question, do we put a regulation on a business? How dare us take away their personal rights? We regulate businesses every single day. I could pick out 50 bills on our list that are going to regulate businesses. Because there's a part where we do regulate business. Sorry. Thank you, Mr. Chairman, and I am definitely for this bill.
Chairman Brown.
Thank you, Mr. Chairman. So as I looked through the amendment and I started reading this bill, originally we had this exact same discussion 2 years ago. I was ardently no on this bill, but might shock some of you that I'm probably going to vote in favor of this bill. And here's the reason why. As I look at this bill has absolutely no enforcement mechanism. None. We passed the Standing Committee Amendment, which takes out the criminal penalty, and it basically just says no person shall do this. Okay. So if I choose to do it, what's going to happen to me? If I'm a business owner and I say I'm going to do this, nobody's going to do anything to me. Well, now we have civil court cases. Now we're going to have to figure out how all these attorneys are going to make lots and lots of money off of civil court cases, because that's the only way to enforce this. That's it. Now, my question on this is actually about the enforcement mechanism. We say that it's based on a person's COVID-19 vaccination or booster status, or whether or not they're wearing a face covering. How do we prove that the regulation that they may be imposing, let's use a hospital, is specifically based on a COVID-19 policy? If they choose to redirect their policies and it doesn't mention COVID-19, then they're not affecting this policy. This Green Book no longer has any implications, right? I think this discussion is a great discussion to have yet again. And I think the vote will probably be closer than it was 2 years ago. But at the end of the day, we have a bill that literally is just a stance from this legislative body. Nothing more. Zero enforcement mechanism. I mean, at the end of the day, if that's what we want to pass out of this body, is just a bill that says you can't do something, but we're not going to have any way that you can enforce it, have at it. Thank you, Mr. Chairman.
Representative Smith.
Thank you, Mr. Chairman. I am in favor of this bill. I just cannot see each and every individual in this room has a different health concern. Everybody's body and makeup is very different. I, for one, have a birth defect to my leg that involves the lymphatic system. One way your body excretes lymphatic toxins is through your lungs. They pool and you develop a chronic cough. When you wear a face mask, you are breathing the toxins. Your body that knows how to heal itself and work is trying to excrete. You're breathing those toxins back in. And I had to make a hard choice between keeping my job or wearing a face mask and jeopardizing my own health. So I chose my own health over wearing a face mask. But I also have to choose, can I get medical attention? Because a lot of the hospitals are still requiring a mask. So instead of receiving care at a doctor's office or hospital, I have to resort to alternative medicines and go to holistic doctors just because I can't go, because they don't honor my own health issues that I'm aware of. But walking in the door, I seem like a perfectly healthy individual, and you wouldn't have a clue that I would have lymphatic issues with my lungs. So I just think, let people make their own choices. If they choose to wear a mask because they feel great, awesome. If they choose not to, awesome. Let people choose. So I am in favor of the bill. Thank you.
Representative Obermueller.
Thank you, Mr. Chairman. Easy to say. The concern I have with this bill, and all the debate has been about COVID, but if you look at the language of the bill, it also says any infectious virus or disease. It's way beyond COVID. Smallpox was deadly, estimated to have killed 300 million people in the 20th century. By the late 70s, a global immunization campaign eradicated the disease. It was the first vaccine for a communicable disease. And I remember as a child standing in a long line at the hospital on the hill in Sheridan to receive the scratch on my arm. We were afraid. You know, our kids were out in front of the line and they were coming out of the hospital crying and it hurt. And we were in this long line, and I remember my dad trying to comfort us. And my dad, being the pastor of the church right across from the hospital, said, son, this vaccine is a gift from God. And he said, you know, it's our patriotic duty to care for our neighbor. So I think it's unclear in this debate who has a claim on the mind of God. COVID worldwide death has been to date about 6.8 million, nowhere near the levels of smallpox. Who could have known that in advance? Did anyone have the crystal ball that said at the time this would never kill 300 million people? It is the fact that it didn't kill 300 million a time for rejoicing and thanks, or a time for recriminations against those who, in the midst of great uncertainty, acted on behalf of society at large? We should not make general policy based on the experience of COVID. Clearly, it could have been much worse. No one knew at the time whether it was another smallpox disease. The fact that this one instance did not rise to the next level is no basis for making general policy against vaccines or masks. This bill is based on a premise that things can never really be that bad, but it can. Historically, it has. Don't tie the hands of those tasked with the responsibility to respond to life-threatening diseases. On and against the bill.
Representative Ottman.
Thank you, Mr. Chairman. There's been such wonderful, thoughtful comments that went on, so it's going to be hard to be brief, but I will. 2 years ago, as a freshman, I came in here not even having an idea of the situation that would go on, to whereas there was even divided groups when we were sworn in because of those that wanted to handle our own health conditions and those that had another idea. During that time, I was able to be on a committee and watch as the department that takes care of our health grew and tried to manage the inoculation and different things that were going on. I also watched as people, doctors and nurses that had been in employment in our rural and city hospitals for years, beg for their jobs and say, we have been working on the front lines. We want to continue to do that. Please let us work. We will manage this. We will do what is necessary. And they were told that unless they succumbed to the mandate, they would be let go, and they were. What we face with a large majority of the bills that we see during this session is money for this and money for that and mental health. People have lost their jobs, they've lost their incomes, they've lost their friends, they were out of school for a year and a half. They have some problems, they have some things to deal with. One of the representatives over here said this bill is moot. It doesn't have any teeth. Well, maybe maybe employers and different people just need to say, our legislature has said that we don't have to have these mandates, that we can make those choices. Maybe that will give the citizens and employers and businesses and individuals and teachers and everybody else that wants to work and take care of their health, maybe that will give them the ability to say, I want to make this choice myself. In a time when we are looking for nurses and doctors, and people in the health profession cannot go to school because they don't want to follow the mandates, we're creating a crisis and then trying to fix it with money. So I would ask you just to really consider what this is and what it's trying to do. It's trying to empower the people of this state to take care of the businesses, to take care of their families, and to do the things that they need to do. So I would ask for your aye vote. Thank you.
Representative Singh.
Thank you, Mr. Chair. For what I do for my job, my job attempted to implement a vaccine mandate on all of its employees. They backed down because of a Supreme Court ruling. I'm on and for this bill. My question is what's going through my head right now is how much influence should a corporation have on an individual's medical decisions? What comes to mind is Article 1, Section 22 of our Constitution, which says that the rights of labor should have just protection through laws calculated to secure the laborer proper rewards for his service and to promote the industrial welfare of the state. A lot of my coworkers were terrified when this mandate came down on us from our corporation because they were not in the financial situation to sacrifice the job that they were in. Frankly, they relied on this job for their health care. We should exercise caution in empowering a corporation and making this decision on an individual's behalf when corporations are undemocratic for-profit institutions that aren't necessarily taking the health of their employees as their top consideration. Who's to say that there has to be a medical emergency for a corporation to mandate a vaccine on their employees? Do the employees have any sort of say over this? I'm on and for this bill. Thank you.
Vice Chairman Larson.
Thank you, Mr. Chairman. I think there's a couple of things, and I'll look to the bringer of the bill, but there are some comments on the vaccine portion of this bill, but I believe that was all moved out in an amendment. So those vaccines, so I'm getting a positive shake on that. So that conversation on vaccine isn't in this bill. Those aren't removed. The other thing I'd like to just mention is I provided the good chairman of appropriations with the amount of money that federal funds that we get in through the Department of Health through healthcare financing. Would we lose all of those? I don't know. I don't know. That's just how much comes in. It's $847 million in a biennium. When the pandemic was going on, I just wasn't a very good mask soldier. I just wasn't. I tried and just failed miserably. And so, but one little bakery that I like to go to get a breakfast bagel on jalapeno required masks. And so I thought that was fair. It's their business. So I just didn't go. And I think that those are the personal freedoms we have. We don't have to patronize those businesses. I do realize in Wyoming that there may not be a lot of choices, but in businesses, but I think the business has the right to make those choices best for them. I asked when I stood up the first time if public in nature was defined. and it's only in the bill in there. So that, that point is not defined in statute to say that it refers to all private as well. So I think that that's subject to either an amendment to define it, or left as it is. I think that it stands on a pretty weak foundation. I also struggle a little bit as I've listened to the proponents of the bill talk about the Constitution allowing individuals to choose their health care choices, and that the government shouldn't be making them for them. But then I hear that it's important for the government to make these healthcare decisions for them, and it just kind of goes back and forth, and I can't see a consistent argument. It just fluctuates, it appears to me, depending on where you're positioned. We see government impose upon the private on business all the time requirements to protect, yet we don't want the government to protect, is kind of the message that I was having, that I was getting, and maybe I was hearing that wrong. We heard about evil corporations and that provide health care to their employers, and how they shouldn't be able to, as a condition of employment, require somebody to have a mask mandate. I just, if I'm paying for the health care of all my employees, and which is important, that as a condition of employment to, in my opinion, if it's my opinion as that owner or that corporation to do that, not all businesses or corporations. But if that's, I just think we have a right to do that. Do we have the right to impose or put people in danger? Absolutely not. I agree with that. But I don't know that this is always is completely to do with healthcare. I think that we have to have the ability to be able to make decisions in our personal life to wear or not wear a mask, to get vaccinated, not get vaccinated. And we're just going to have to navigate this, but I think imposing this restriction on the ability for businesses and how they want to do that is wrong, and would end with
Representative Knapp.
Thank you, Mr. Chairman. Not quite yet. I feel like I'm back in special session. And some of us would roll our eyes and think, move on, correct? But I would like to say that this may be one of the most important bills we discuss. This is a bill about your personal rights as protected by the Constitution. So how clever was the federal government that they could do a mandate of masks, a mandate of vaccines, and a mandate of tests? The federal government began to create a new class of citizen. And it was a class that would be restricted from going to places to eat. It would be a class of citizen that would be restricted of travel. A class of citizen that couldn't enter government buildings, couldn't get healthcare access. In some countries, that class of citizens now is sequestered in camps. These are fundamental rights. Your health is a fundamental right. It's not about businesses' rights. The businesses were mandated. A business didn't just come up and say, you know what, no shirt, no shoes, no service, and by the way, you got to be vaccinated. These were mandated to businesses to not have a choice, done through blackmail, done through, we've heard it before, done through funds that would be taken away. This was not laws that were passed down by Congress. These were mandates to take away a fundamental right guaranteed by the Constitution. So when we sit here listening to discussion, and it's been a good debate, I would just remind the body, what are you willing to give up? What specific rights are you willing to give up that you can't walk in a business, that you can't travel, that you can't go see your doctor? For me, I believe that this is a fundamental question that we face, and that's why this bill is important. Thank you.
Representative Penn.
Thank you, Chairman. Let me just help you understand what Wyoming actually experienced with COVID. Because we look at across the country and we saw a lot of things happen in New York. What did Wyoming do? One case in Fremont County, the state was locked down. One case. We sent our kids home from school for initially 2 weeks. Sometimes that became a year. In Wyoming, that happened. What did I see as a nurse practitioner? So let me tell you a little about what I do. I handle urgent care in Fremont County and at probably one of the largest clinics in the state. I personally have seen a few thousand patients for treatment of this. On my biggest shift, I saw 85 patients in one day with COVID or COVID-like symptoms that we were managing. On the news, we were seeing how people were dying and all these things. And I'm not trying to make you think that I think that people didn't die from this. I have family members who died from COVID. Or I guess the question is, did they die from COVID or did they die from the protocols that were put in place to treat COVID? And that's a real question. You can say that that's a conspiracy theory. It is not. But what did I see? We were this close to calling in the National Guard because across the parking lot we had the one case. And so we called in lots of extra staff, and what did we do? We sat on our tushies and we didn't see any patients. We turned people away at the doors. You can't be sick. If you're sick, go home and give us a call on the phone. You can't come in if you're healthy, because what if someone else is sick? We sat for actually a few months and I would see 1-2 patients a day, when typical for me is 20-ish. Finally, about 6 months later, we started seeing the cases rolling in. And as this was before the vaccines, mind you, as that happened, a very common statement that I started hearing from patients who were testing positive for COVID. Oh, that's COVID? I thought it was my allergies. I thought that there was a sniffle. I thought I had a cold. This was before the vaccines. These are the things that we saw. The question is, who gets to determine what is the threat here? You say that the government, someone made a comment about the government protecting us from COVID. Do we get to say that the government gets to determine what the threat is for us? Because as we look back, it's felt by very many, and this is substantiated with evidence within the practice of medicine, that the threat for many was not actually COVID, but the way that we handled it. The other thing is, we only look at COVID. We only look at the number of people that died from that thing. But what about the fallout of these mandates? What about what happened to the kids? What about the increase in sexual abuse, in child abuse, the decrease in the learning and abilities of our children? There are so many things that are the fallout that we're not even paying attention to here. And so I say, once again, let's protect liberty first.
Representative Byron.
Thank you, Chairman. I'm going to try to bring this back to House Bill 66. I look around from the back of this room and I don't see it up on anyone's computer or on their desk. So Article 1, Section 20 of our great Constitution. Every person may freely speak, write, and publish on all subjects. So my question, because I'm conflicted right now on this bill, page 3, no person shall, it goes on to say, publish, display, or mail, either directly or indirectly, any communication, notice, or advertisement, et cetera, et cetera. So I have a conflict there, so I don't know if the speaker would like to, the bringer of the bill would like to, comment on that, but I have these two sheets and I don't know where I'm gonna land on it due to some conflicts with the actual language of the bill.
Representative Hornock.
Thank you, Mr. Chairman. I'm just want to remind the body of the 67th how good we are. Because of this debate, and we're about to get done in maybe an hour or two, something that took the last session more than 3 days to do, and they didn't accomplish anything. So keep up the good work. This is the issue that many of us were sent here to take care of by our constituents. We're about to do that, and I appreciate the debate. I appreciate the good comments. I ask you to take care of this issue once and for all on and for the bill. Thank you.
Representative Stith.
Mr. Chairman, just to clarify something, earlier the discussion was whether this bill applies to a person's COVID-19 vaccination status, and reading the amendment together with the main bill, it appears that it does still include vaccination or booster status. So if you look on the Standing Amendment Committee, Amendment number 1, on lines 7 through 10 of that amendment, it modifies, excuse me, on the amendment sheet, lines 5 through 9, what it does is, in the main bill, it limits it to COVID-19, but as amended, it reads, no person shall refuse, withhold from, or deny to a person any services, goods, facilities, advantages, or privileges that are public in nature or that invite the patronage of the public based upon a person's COVID-19 vaccination or booster status. Thank you.
Speaker Summers.
Mr. Chairman, thank you. And I originally asked this question about, could a doctor require a nurse to wear a mask? And as I look at the plain language of the bill, I don't think a doctor could force a nurse to wear a mask during surgery. And so the question I ask is, does that individual laying on that surgical table have a right to life and to be protected by the people that are trying to serve them? And I think that individual on that gurney has a right. And so maybe I'm reading this wrong, maybe it wasn't crafted properly. This is not just about COVID-19. COVID vaccine, I'm with you on that. I mean, whatever on that, but this is about what this could affect that's not that. What are the unintended consequences? That's what I would ask you. And I just, I think that guy or gal on that gurney has as much right to life as anybody else.
Chairman Harshman.
Thank you, Mr. Chairman. Kind of like to just, I think I'm the last one who hasn't spoken on this bill, maybe. But I think the good representative from Cheyenne, and I just think, when I look at all these people up in these portraits looking down at us who have had these same debates in this chamber, and it's really about, it's the old saying, your right's in where my nose begins. And there's always this balance. And so to say, the 66th debated this for 3 days. The 65th had issues like this are debated. The 64th and the 63rd, and surely the 68th will continue these debates, and the 168th. And so I think it's, I just want to commend the body. This has been really, this is what we do. And then the other part of this is we sit in these seats. We all have conflicts, right? And we all have a certain amount of hypocrisy. I like certain boxes full of money. Some call coffee cans that you don't like. You like certain ones that I don't like as much. And we all have, but in the end, some of us like certain coffee cans. And you've seen that in the debate. And I think that is the beautiful part of this House of Representatives. So I just think emotional issue. We've all lived through it. And wherever you're at on this, I just appreciate the debate. And this will never be solved, nor should it be. These same issues will always be talked about: education, water, transportation, criminal justice, individual rights, healthcare. And so we continue the work that many others who sat in these chairs did before. So appreciate the good debate, Mr. Chairman. And I think I can't call for the question. There's still folks signed up at the mic, but I thought I'd try.
Representative Jennings.
Thank you, Mr. Chairman. I'll do that if you want at the end of this, but hopefully it won't take very long. So this is a very difficult decision. And this is not a panacea. It will not fix these problems. And most of you probably think of me as a little bit conservative from time to time, on occasion. And I've heard the argument about business. Well, the first thing that I wanted to look at with business is that business rights also were trampled upon. They were threatened with taking of their license if they didn't. Some businesses fell in with government and were happy to do so. Other businesses, it harmed them. I remember seeing my barber, and he was declared non-essential. I know, this is an easy job. There's not as much to cut as there used to be, right? Maybe not as essential as it used to would have been for me. He nearly lost his business. He asked me one day, he said, "I'm going to lose my business if I don't open these doors." Now, he took caution. He was very careful. I said, "Well, if you open your doors, I'll try to be your first customer." And I wasn't. I was number 2. We put all kinds of regulations on businesses. That thing's full of them. Good and bad, right and wrong. This bill will not solve every problem that comes up. But those businesses, for me as a conservative, as an individual, not speaking for any of the rest of the 61 of you, I have concluded that those businesses are made up of individuals, and that I have to stand with the people's rights, those individuals' rights first. And I think that it's very important that we think about that. Like I said, we're not going to solve this today. This bill is not going to fix all of the problems. I would argue that this bill does stand for individual rights first. It'll get amended. It'll get changed. We'll be back to discuss it again. But from the standpoint of individual rights and our constitutional rights and the things that made this country great, one of the earlier speakers brought about other countries and the way that they've handled things and how that has brought about loss of freedom in those countries. I don't want to see that here. These people up here is who we're working for, and they have individual rights, and we're to care for those. Do we care about businesses? Yes, we do. And sometimes those rights are in conflict. And I'm not telling you that we're going to solve every business's rights, that we're not going to trample on some. I'm willing to bet this Green Book has trampled on some business rights. It happens. But for me, I'm going to stand for the individual rights first. I'm going to do everything I can for companies and businesses. Hey, I love free market. Those guys out there are the best of the best. But when they hold hands with government and our government does overreach, I'm going to stand for individual rights first. So on and ask you to vote aye for the bill.
Representative Western.
Thank you, Mr. Chairman. Because our good Majority Floor Leader has his voice is gone, he did ask me to read a note saying on and for the bill, Mr. Majority Floor Leader.
Question being called. All those in favor of Representative Ward's motion that when the committee of the whole rises to report, it do so with the recommendation that House Bill number 66 do pass, please say aye. Aye. Those opposed, no. Division has been called. All those in favor, please stand. All those opposed, please stand. House Bill 66 has passed the committee of the whole.
Mr. Chairman, point of order, could you tell us the vote count on that, please?
31 to 29. Representative Western.
Thank you, Mr. Chairman. Folks, I think that was a pretty heavy debate, so I consulted with a good majority floor leader, and I make a motion that the committee of the whole rise and report, the committee rise and sit again for 10 minutes. Just take a little break, go grab some water, stretch your legs, we'll set it back down in 10 minutes. Best I can come up with.
You've heard the majority whip's motion. All those in favor say aye. Any opposed? No. We're stand adjourned for 10 minutes. Stand for recess for 10 minutes. The Committee of the Whole, please come to order. Stand at ease. Majority Whip Western.
Thank you, Mr. Chairman. I move that the Committee of the Whole rise and report.
All those in favor of the motion, say aye. Those opposed, say no. Motion carries.
The reading clerk will read the Committee of the Whole report.
Mr. Speaker, your Committee of the Whole, having had under consideration bills on general file, begs leave to report as follows. House Bill 22, due pass amended. House Bill 83, due pass. House Bill 169, due pass amended. House Bill 144, due pass amended. House Bill 64, due pass. House Bill 66, due pass amended.
I move the adoption of the Committee of the Whole report.
You have heard the motion. All those in favor say aye. All those opposed, no. The motion carries. Congratulations, Representative Nemec. First, I just want to thank everybody for the debate. I think we did a really good job of getting our point across, keeping things civil. You know, that's what we should and do. We should do here, and we did. So I'm really appreciative of the good work we did. So, with that, do we have any messages from the Senate? Messages from the Senate.
Message 187. Mr. Speaker, the bill listed below passed the Senate on third reading in an amended form by the vote indicated. Senate File 17, off-road recreational vehicles, safety and insurance. Ayes 30, noes 1. Message 188. Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. Senate File 24, financial exploitation of vulnerable adults. Ayes 22, noes 9. Message number 189. Mr. Speaker, the bill listed below failed to pass the Senate third reading by the vote indicated. Senate File 54, Judges Housing Allowance. Ayes 15, noes 16. Message 190. Mr. Speaker, the bill listed below passed the Senate on third reading in an amended form by the vote indicated. Senate File 72, Employees Forced Microchip Implantation Prohibited. Ayes 19, noes 12. Message 191. Mr. Speaker, the bill listed below passed the Senate on third reading in an amended form by the vote indicated. Senate File 76, Wyoming Digital Asset Registration Act. Ayes 30, noes 1. Message 192. Mr. Speaker, the bill listed below passed the Senate on third reading in an amended form by the vote indicated. Senate File 82, Eligible Water and Sewer Project Funding. Ayes 31. Message 193. Mr. Speaker, the bill listed below passed the Senate on third reading in an amended form by the vote indicated. Senate File 108, Court Reporter Fees, District Court Discretion. Ayes 31. Message 194. Mr. Speaker, the bill listed below passed the Senate on third reading in an amended form by the vote indicated. Senate File 116, Protection of Lawful Commerce and Firearms. Ayes 29, noes 2. Message 195. Mr. Speaker, the bill listed below passed the Senate on third reading in an amended form by the vote indicated. Senate File 61, Legislator per diem. Ayes 16, noes 15. Message 196. Mr. Speaker, the bill listed below passed the Senate on third reading in an amended form by the vote indicated. Senate File 112, Peer Support Counseling, Confidentiality. Ayes 31. Message 198. Mr. Speaker, the bill listed below failed to pass the Senate's third reading by the vote indicated. Senate File 114, Constitutional Instruction and Examination Requirements. Ayes 15, noes 16. Message 199. Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. Senate Joint Resolution Number 3, Property Tax Exemption for the Elderly and Infirm. Ayes 21, noes 10. Sincerely, Ellen Thompson, Senate Chief Clerk.
Reports from standing committees.
House Bill 99, sponsored by Revenue, Property Tax Refund Program, an act relating to property tax. Mr. Speaker, your Committee Number 3 Revenue, to whom is referred House Bill 99, Property Tax Refund Program, respectfully report same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Baer, Byron, Harshman, Locke, Northrup, Oakley, Storer, Strzok, Zwanitzer. Representative Harshman, Chairman. House Bill 121, sponsored by Representative Lawley. Property Tax Deferral Program Amendments, an act relating to property taxes. Mr. Speaker, your Committee Number 3 Revenue, to whom is referred House Bill 121, Property Tax Deferral Program Amendments, respectfully report same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Baer, Byron, Harshman, Locke, Northrup, Oakley, Storer, Strzok, Zwanitzer. Representative Harshman, Chairman. House Bill 123, sponsored by Representative Berger. Collection of antler or horns by residents and non-residents, an act relating to game and fish. Mr. Speaker, your Committee Number 6, Travel, Recreation, Wildlife, and Cultural Resources, to whom was referred House Bill 123, collection of antler or horns by residents and non-residents, respectfully report same back to the House with a recommendation that it do pass. Ayes, Representatives Angelos, Burkhart, Byron, Larson, Singh, Storer, Western, Winter. Excused, Representative Newsom. Representative Western, Vice Chairman. House Bill 160, sponsored by Representative Pendergraft. Driver's License Veterans Designation replacing DD Form 214, an act relating to Defense Forces and Affairs. Mr. Speaker, your Committee Number 8, Transportation, Highways, and Military Affairs, to whom was referred House Bill 160, Driver's License Veterans Designation replacing DD Form 214, respectfully report same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Berger, Brown, Nemec, Obermuller, O'Hearn, Pendergraft, Smith, Stivar, Wiley. Representative Brown, Chairman. House Bill 182, sponsored by Appropriations. Skill-Based Amusement Games Amendments, an act relating to gaming. Mr. Speaker, your Committee Number 2, Appropriations, to whom was referred House Bill 182, Skill-Based Amusement Games Amendments, respectfully report same back to the House with the recommendation that do pass with the following amendments. Ayes, Representatives Henderson, Larson, Nicholas, Stith. Noes, Representatives Sherwood, Walters, Zwanitzer. Representative Nicholas, Chairman. House Bill 190, sponsored by Representative Harshman. Wyoming Value Added Energy and Industrial Plan, an act relating to the administration of government. Mr. Speaker, your Committee Number 2, Appropriations, to whom is referred House Bill 190, Wyoming Value Added Energy and Industrial Plan, respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Henderson, Larson, Nicholas, Sherwood, Stith, Walters, Zwanitzer. Representative Nicholas, Chairman. House Bill 208, sponsored by House Appropriations. School Foundation Program Reserve Account Investments, an act relating to school finance. Mr. Speaker, your Committee Number 3 Revenue, to whom is referred House Bill 208, School Foundation Program Reserve Account Investments, respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Baer, Byron, Harshman, Locke, Northrup, Oakley, Storer, Strzok, Swanitzer. Representative Harshman, Chairman. House Bill 209, sponsored by Capital Finance. Hathaway Scholarship Accounts, Transfer Timing, an act relating to education. Mr. Speaker, your committee number 3 Revenue, to whom is referred House Bill 209, Hathaway Scholarship Accounts, Transfer Timing, respectfully report same back to the House with the recommendation that it do pass. Ayes. Representatives Bear, Byron, Harshman, Locke, Northrup, Oakley, Storer, Strzok, Swanitzer. Representative Harshman, Chairman.
Re-referrals, Chairman Harshman, Chairman Harshman. Chairman Harshman, you've got a re-referral. Yeah. 121.
Thank you. Mr. Speaker?
Please.
Thank you. Mr. Speaker, I would re-refer House Bill 121 to our Appropriations Committee. Thank you, Mr. Speaker.
Seeing no objection, House Bill 121 is referred to Committee Number 2 Appropriations. Mr. Majority Whip, let me see, does that clear the deck? Mr. Majority Whip?
Thank you, Mr. Speaker. In lieu of our good Majority Floor Leader, who obviously lost his voice, I want to announce the general file list for tomorrow. We're going to start with 149, 161, 133, 57, 30, 27, 128, 126, 129, and 145. Does anybody need me to repeat that? Raise your hand. No?
Vice Chair Larson, do you have a privilege?
Privilege, if I may, Mr. Speaker. I'm finding out that after I spoke to this group today and talked about the budget bill and the summary sheet, that there's been somebody to say, what's this budget bill? I can't find my budget bill. Well, it's a big fat bill and it should be on your desk and it should say HB 0001. Yeah. So look for it. If you don't have it, I mean, it'll be difficult to follow without. Okay? Mailbox. I've heard mailbox, but sure, we need to have it.
Thank you, Vice Chair Larson. Majority Whip?
Thank you, Mr. Speaker. I make a motion that the House adjourn until tomorrow, January 27th, 2023 at 10 a.m.
Committee announcements. Chairman Zwanitzer.
Thank you, Mr. Speaker. Your committee number 10, Labor, Health, and Social Services, is going to meet at 7:30. First time we've met that early, 7:30 a.m. in E3 to hear the following 3 bills. House Bill 122, Anesthesiologist Assistant Licensing, House Bill 179, Medical Care for Wyoming Communities, and House Bill 206, State Employee Child Care.
Chairman Burkhart.
Thank you, Mr. Speaker. Your committee number 9, Minerals, Business, and Economic Development, will meet at 8 a.m. tomorrow morning to consider potentially 4 bills. First bill being House Bill 118, Volunteer Firefighter Pension Funding, House Bill 196, Wyoming Infrastructure Protection Act, House Bill 213, Energy Production Inventory Exemption, and if time permits, House Bill 239, Vehicle Idling Decriminalization.
Chairman Washut.
Thank you, Mr. Speaker. Your committee number 1, Judiciary, will meet at 7:30 tomorrow morning in our regular meeting room, East number 1, to consider House Bill 157, County Board Dissolution, House Bill 172, Evidence Preservation, House Bill 186, Court-Appointed Attorneys, and House Bill 214, as time allows, General Regulatory Sandbox.
Chairman Olson.
Your committee number 7, Corporations, Elections, and Political Subdivisions, will meet tomorrow upon noon recess in room E005 to consider 4 bills. House Bill 173, Records Available to Post, continued from 1/25/23. House Bill 102, the Election Recount Amendments. House Bill 135, Cities and Towns Abandoned and nuisance buildings, and House Bill 189, Homeowners Association display of political campaign signs.
Chairman Northrup.
Thank you, Mr. Secretary. The Education, your committee number 4 will be meeting in room 3, and we'll be doing House Bill 176, so we're going to finish that one up, which is K-12 education standards and assessments. House Bill 137, minors, sales and purchase of cannabinoid products. House Bill 140, mental health area. We're stuck on that mental health access collaborative care model, and House Bill 151, property tax exemptions.
Chairman Nicholas.
Thank you, Mr. Speaker. Your House Appropriations will meet at noon or shortly thereafter to continue work on House Bill 89, and then we will also do House Bill 264, 269, Joint Resolution 6 and Joint Resolution 7, and a re-referral of 121.
All right, you've heard the majority whip's motion. All those in favor say aye. All those opposed, no. Motion carries. The House is adjourned until 10 a.m. tomorrow, January 27th, 2023.